All right, let's jump right in. We are looking at a high-stakes family drama today that literally collides with the supreme law of a nation and major international treaties. We're unpacking an absolute landmark judgment from the Constitutional Court of South Africa, case CCT 53/00. And look, this isn't just some dry legal text. It's a profound, real-world look at how courts have to navigate the incredibly messy, frankly heartbreaking reality of broken families across international borders. So it brings us to this core dilemma. Imagine a 4-year-old girl. The court documents call her ST, who was taken from British Columbia, Canada, all the way to South Africa by her mother. But then, the mother refuses to return her. It sparks this massive cross-border legal battle. On one side, you've got global treaties absolutely demanding the child's immediate return. And on the other, a mother desperately pleading that going back would put both of them in an intolerable, dangerous situation. What do you do? Part 1. An international family dispute. Let's trace the steps from Canada to South Africa. To really grasp the gravity of this ruling, we need to quickly look at how this all started. The parents immigrated to Canada in 1997. By 1999, things had broken down and they separated. They drew up a custody agreement in British Columbia. Now, the mother had sole custody, but, and this is a huge detail, they shared joint guardianship. And there was a strict, non-negotiable rule that neither parent could permanently remove the child from the province. Fast forward to June 2000, the court allows the mother to take her daughter on a 30-day trip to South Africa. But when July 14th rolled around, they never got on the plane back. Just like that, a legally permitted, standard vacation turned into a potential international abduction. Part 2. The Hague Convention Explained. We're looking at the rules of international child abduction. So the father's immediate response was to request his child's return under the Hague Convention. If you're not familiar, this is a massive global treaty designed specifically to stop parents from fleeing across borders with their kids. The whole case hinges on how the convention defines rights of custody. You might be thinking, wait a second, didn't the mother have sole custody? Well, under Canadian domestic law, sure, but under international Hague law, custody actually includes the right to determine where the child lives. Because their agreement had a strict non-removal clause, a ne exeat provision, the father legally held rights of custody on an international level. By staying in South Africa, she breached those rights, which triggers the treaty's mandatory return procedure. Part 3. A constitutional clash. International treaties versus the best interests of the child. Now we hit the real legal fireworks. You have this intense tension. The Hague Convention has a rigid, almost unbreakable mandate. If a child is wrongfully retained, they must be promptly returned to their habitual residence, period. Well, enter Section 28(2) of the South African Constitution, which declares that a child's best interests are of paramount importance in every single matter concerning them. The mother essentially argued, look, blindly sending my daughter back to a hostile environment in Canada completely violates the South African Constitution. The Constitutional Court somehow had to reconcile this clash. Justice Goldstone, who wrote for the court, pointed out a really crucial distinction here. Ordering a return isn't about deciding long-term custody, not at all. It's purely jurisdictional. It's simply deciding which country's court is in the best position to figure out what those best interests are. By sending the child back, the South African court is just saying, hey, the Canadian courts, where the family actually lived, where all the evidence is, they are the proper forum to decide who gets custody. Part 4. The mother's defense. Here's a look at the Article 13 exception. But you have to ask, what if returning the child literally places them in harm's way? The Hague Convention isn't totally heartless. It actually has a critical safety valve built in, called Article 13. This lets a country refuse a return order if there is a grave risk that going back would expose the child to physical or psychological harm or put them in an intolerable situation. It's a notoriously high bar to clear, but it became the absolute center of the mother's defense. And she wasn't just throwing around abstract legal theories here. She was claiming very real, imminent danger. She submitted these extensive affidavits that painted a deeply troubling picture of the marriage. We're talking about a physical assault in 1998 where she was thrown against a kitchen counter, 2 separate peace bonds issued against the father in Canada, highly erratic, intimidating behavior, like allegedly gluing the locks of hunters' cabins and filling light bulbs with brake fluid. On top of that, her daughter was a special needs child who was finally thriving in South Africa, whereas back in rural British Columbia, they'd be totally isolated. And the kicker? Because she defied the Canadian court, there was literally a warrant out for her arrest. Going back, in her eyes, was completely intolerable. Part 5. The court's decision and evaluating the grave risk thresholds. So, the South African Constitutional Court had this agonizing task. They had to impartially evaluate if these really serious allegations met that strict legal threshold to permanently halt the return. And when they looked at the evidence, they made a major distinction. They absolutely acknowledged the intense hostility, and they saw the mother's genuinely tough position. But they noted there were zero allegations that the father had ever abused the child. Reports actually showed he was a very involved, loving dad. The court ruled that the psychological harm the mother feared was basically the natural consequence of a bitter custody dispute, not the grave risk of serious harm to the child that Article 13 requires. Since the danger wasn't directed at the child herself, that strict threshold just wasn't met. The child had to be returned. Which leads us to a very human question. If the court orders the child back, and the mother is staring down an arrest warrant, zero income, and no place to live in Canada, does the law just wash its hands and force them into a financially devastating, hostile nightmare? Part 6. The Protective Conditions. Let's see how they balance the return with strict safeguards. Thankfully, the answer to that is a resounding no. Yes, the court mandated the return, but they used their broad constitutional powers to legally shackle the father with prerequisites. Before the mother and child even had to pack a bag in South Africa, the father was ordered to secure a Canadian court order guaranteeing a whole list of things. He had to get the arrest warrant against the mother withdrawn. He had to pay $500 Canadian a month for her separate housing, another $500 for child maintenance and schooling, provide a roadworthy car, cover all medical and therapy expenses, and buy their plane tickets back. If he couldn't get a Canadian court to sign off on all of that within 30 days, the mother could ask the South African court to scrap the return entirely. Plus, the court clearly recognized the intense, toxic friction between the parents. To totally insulate the mother from the tension she described, the court laid down a strict rule. The father gets reasonable access to his daughter, sure, but it has to be arranged without a single point of direct contact between him and the mother. They flexed their constitutional muscle to ensure that obeying international law didn't mean abandoning basic safety. This case really is a masterclass in judicial balancing, isn't it? It upheld a crucial international treaty meant to stop child abduction, but it absolutely refused to do so blindly at the expense of the vulnerable people involved. So, I'll leave you with this final thought. As borders become easier to cross and families become increasingly global, how will our courts continue to weigh the rigid, black and white demands of international treaties against the very real, very messy, human realities of family breakdowns? Thanks for joining this explainer, and keep questioning the frameworks that shape our world.